Welcome to the Greater Zion Law Podcast.
Welcome to the Greater Zion Law Podcast with attorney Travis R. Christiansen. Travis is a Southern Utah attorney who helps individuals and families protect what they've built through practical estate planning designed to avoid confusion, conflict, and unnecessary legal problems down the road. I'm Lisa Mosbey, your host, and today we're talking about what documents actually make up a complete estate plan in Utah and why each one matters. Welcome, Travis. Thank you so much for joining me today.
Hey, it's good to be here, and it's good to be talking about something that I feel passionate about because of the positive impact it has on families, sometimes for generations. So this is just an important topic. So thank you.
And you know, Travis, before I let you get into the documents themselves, I'm curious what led you to estate planning work and what kinds of situations made you realize how important good planning can be for families?
Well, you know, in large part, it was because early in my career, some of the cases I did were probates, where you had brothers and sisters fighting over a pittance that mom and dad had left them because mom and dad hadn't done their planning. And so it was always this, well, mom said I could have it and dad said I could have it. And, you know, it just became a mess and I saw families get destroyed. So really, to me, estate planning becomes about helping preserve family peace and family relationships. Because of those fights that I saw early on in my career, I realized how important and valuable getting your estate planning done when it's necessary and getting it done right.
And I'm with you on that. After losing both of my parents, I know the value of it. I'm going to let you loose now. What documents are usually included in a complete estate plan in Utah, and what purpose does each one serve?
All right. So in an estate plan, we've got a handful of documents we always do, and then you can do others if it becomes necessary under a specific circumstance. So the first is what's called a trust agreement. The trust agreement is the document that creates a trust. And trust, there's dozens of types, but for most people, we do what's called a revocable living trust. And it's kind of a weird situation where you take your stuff and say, hey, I'm going to give my stuff to me as the trustee to manage my stuff for myself, or, you know, married people do it. And so it's kind of this weird fictional thing where we're taking our stuff, giving it to us to use for us. And so that's kind of the first document that we do. Then we do what we call a pour over will. A pour over will is kind of the safety net, if you will. So years ago, the way I describe this to folks is I went up on the Empire State Building 30 something years ago, and I don't know if you've ever been up there, but there's a solid wall about waist high, and then there's this fence. It's just like in the movies. It goes up 5 or 6 feet, then back over the top of your head 5 or 6 feet. So I thought, I'm from Southern Utah, and we've got a couple of great cliffs here. One's called Angel's Landing that's 1,500 feet straight down. You can lay on your belly and stick your head over and look down, and it's 1,500 feet. So I'm like, hey, I'm up on the Empire State Building. I wonder what it looks like to look straight down. So I push my head against the fence, and I look straight down. Maybe 20 feet down, there's these great big nets hanging off the side of the building. So I'm like, okay, this is weird because the wall, the fence, dozens of tourists, there's a security guard on each of the 4 sides. So I went over to one of the security guys and says, hey, nobody jumps, right? He says, yeah, it's been decades since someone successfully jumped off the Empire State Building. So I said, so what are the nets for? He said, well, you'd be stunned at the things people will throw off of the Empire State Building, just for sake. And then he's like, have you ever seen a quarter? Great, you know, New York accent. I can't even do it. I don't even want to try. But have you ever seen a quarter hit pavement from 1,000 feet? It'll embed itself. So imagine that top of somebody's head. So they've got these safety nets to protect everybody down below because people throw money. Oddly enough, Tiffany engagement rings. Guys go up there and propose. Girl tells them no, and they in a fit throw it off. So he says, every few weeks we go down there and there's some windows that we can open. We gather all the stuff and donate it all to charity. So if you will, your trust is the Empire State Building. The pour over will is those safety nets because inevitably we might miss something in your estate planning, an asset that wasn't put in your trust. Maybe you bought a new car 6 months before you died and it was in your own name. The pour over will, in this case, will push the assets so that they're in the trust for administration. The next document we typically do is a power of attorney. This document is used once you become incapacitated. So somebody can take over managing your personal affairs Now, there's a couple of different ways you can do a power of attorney. My preference is a springing power of attorney. Some estate planning attorneys like immediate powers, but then I've seen an immediate power abused. I've had some divorce cases. I do a little bit of that as well, where the spouse had planned the divorce for years and had been using an immediate power of attorney to move assets so they were all in their own name. And then they waited long enough, or in the names of other family and friends, and waited long enough so that those transactions couldn't be undone by the court, and then filed for divorce. And we got nothing as a couple. So I like the springing where you have to be incapacitated, or there's some other conditions that might meet individual circumstances. I've had clients that want to take one of those around the world 90-day cruises. So it'll say, look, if I'm out of the country for more than 2 weeks, the power of attorney can be used by my family. And I actually had a situation on that where we had it that if this couple was out of town and they were out of town in the winter and it had been more than 2 weeks and pipes broke in their house, because their kids had that springing power of attorney, they could then go in and get the restoration experts in and the flood mitigation people and get their house repaired while they were gone. They wouldn't have been able to do that without that power of attorney in place. So we have that financial durable power of attorney document. The next one is a living will / advance directive to healthcare providers. And that's the pull the plug document for most people. It allows somebody else, if you're not able to make medical decisions on your behalf. The next document is usually a certificate of trust, which is a summary of the powers of the trustee. So you're not giving the entire trust to the banks and some of those people you're dealing with. They get this summary so that they know the trust is allowed to do certain things. Usually in that healthcare power of attorney, there's going to be a HIPAA release so that that person can get access to your medical records. If they need to make medical decisions for you, they can get the information to make those decisions. My office, one of the things we will always do is record the deed to your primary home as part of what we do. Because the one thing about a trust is if you don't have beneficiaries, you can find beneficiaries. You can go to court and say all the beneficiaries in this trust are dead. You can find people to give stuff to. If all the trustees have died, you can find a replacement trustee. But if there's no assets in the trust doesn't exist. So we will always record the deed for you, and that's part of what you pay when you hire us to do that, is the recording fee for the deed and the drafting of the deed. We will always make sure that happens for you so that that's in the trust. Just make sure if you do something in the future, such as refinance, the title company puts the house back in to your trust. Otherwise, it's all for naught. Then we're having to use the will safety net to put it into the trust and distribute. So those are the basic documents in an estate plan. We do a couple others. There's an instruction letter that kind of tells you when you go to the bank, how to title your bank accounts in the trust and some of those kind of things.
So I have a few little tweaks or questions on some of those, more details actually. So let's talk about a pour over will. I get it. When it goes over the fence, it catches everything. But what does it actually control? Where do families sometimes misunderstand what that will can do and cannot do?
Yeah. So hopefully it's never used. Hopefully it's just paper that just sits there and gathers dust because everything is in the trust. The idea is if there are assets that, I'll tell you a story. So maybe 6 years ago now, I did an estate plan for a guy, and 6 months later, he refinanced his house. And when he refinanced the house, he got a great interest rate, saved some money and all of that. But the title company that did that refinance, the recording of those documents, didn't deed it back into the trust. He died 4 months later. So his 2 sons show up with this binder of stuff saying, hey, our dad did the estate plan. And so we said, well, let's look at it. And so we did a quick title search to make sure. And because the title company had screwed up, we had to do a probate. And at that point, we used the pour over will to take that home, put it into the trust, and then distributed the assets according to the trust. That's one thing. Now, the other thing that the will can do applies to younger people. So in your will, if you've got young kids, so if you're, so there are 2 critical categories in my mind of people that need estate planning done. The first is those people that are approaching death. You're 60, 70, and you may die anytime. And you need that estate plan to avoid probate, right? The other critical group that most people don't even think about is if you've got kids that are under 18, your will pour over will is kind of the name. But in that document, we specify if we die and we still have little kids, we want this person to take care of their persons, their bodies, raise them essentially in our stead. And we want this person or persons to manage their money. And it's sometimes the same person, sometimes different. But those are the two main areas where the will becomes a needed document, even though you've got one or more trusts that are going to do the heavy lifting of your estate plan. It's that safety net. And in those categories where something was moved out inadvertently, or you've got kids that you need to be able to name a guardian and conservator for.
Great examples. It really helps for us to understand these different documents and how they work. Can you share a situation where having the right estate planning documents in place helped a family avoid confusion, conflict, and major legal problems?
One of my favorite appointments to do as an attorney is I get the call from one of my clients' kids. Hey, mom died Saturday and this is Monday. What do we need to do? And I'll say, you know what? You mourn. You call me in a couple of weeks. You go have the funeral, have the service, cry, do that stuff that you've got to do because your parents had a plan. And you call me in a couple of weeks and come and see me. And then they come in a couple of weeks. And in the meantime, my staff and I, we've checked the recorder's office. Great. The house is still in the trust. It's what we wanted to see. That our quitclaim deed or special warranty deed was the last document recorded on that piece of property. Because then that family comes in and they sit down and they say, what do we need to do? And I just say, were the bank accounts in the trust? And they show me the checkbook. The top of it says, if that family trust, if the bank accounts in the trust, the real estate's in the trust, all they need to do is whoever the successor trustee is, they need to take copies of the death certificate into the bank, up to the county recorder's office, and they're in charge. That's it. It's that simple. Some counties require us to prepare what's called an affidavit of survivorship, basically saying, hey, the trustees are dead and I'm the successor trustee. You prove ID. Here's my ID. Record that document with a death certificate. You're done. You're in charge. You can now sell the home, get in the home, distribute the asset just how mom and dad wanted it done. And that's the best part about this work is when that family who has just lost their parents, that appointment with me is, hey, everything's done. Thank you. I love you. I appreciate what be grateful for your mom and dad and what they were able to get done. So this part of losing them became the easiest part.
And Travis, do all families need a trust or is this only for rich people?
So here's what I would say. If you own real property, you need a trust. That's my general rule. Because there are certain assets, no matter what, have to go through probate unless they're owned by an entity like a trust. One of those is real property. If you own real estate, a home, land somewhere, some timeshares that have real property title to them, those things, if you don't have a trust, you're going to be drug into probate. Now, the rich person thing is Utah and a lot of other states have what they call a small estate affidavit. So if your net worth is less than 125 or 150,000. Our legislature keeps changing it. I have to look it up once in a while. It's about there. If you don't have more than that, you may not need any estate plan because their family can just fill out a small estate affidavit and go on with it. Now, if you don't have a lot of money and you've got kids and you don't want those meager assets you have wasted, then you want to set up a trust. And I'll give you an example on this. So let's say you have a couple of kids, you might have a couple $100,000, and the law says when they're 18, they get their share. So if you've got two kids and you got to have $100,000 in savings or just whatever, and you hand an 18-year-old $50,000, what are they going to do with that?
Blow it.
Yeah. I'm 2 hours from Vegas, everything on black, right? Or they're going to buy the big fancy truck they always wanted, or they're going to blow it because they don't. The science has said the prefrontal cortex, a part of our brain that manages our rational thought, doesn't fully mature until you're like 26, right? And so even in that situation, a trust allows you to control your money beyond the grave. But you can say, look, I got this little bit of money and my kids can't have it until they get a bachelor's degree or its equivalent in the trades, right? They become a journeyman electrician, journeyman plumber, and then they can have it. In the meantime, the successor trustee I have designated is going to manage that money, maybe help pay for school, help buy textbooks, help do those kind of things. So there's so many cases where a trust can just really help and bless a family that it's hard to say when it's not needed. Now, having said that, I've had people bring in their mother who's 85 and she's going into a home and she's got a couple of $1,000 in her Social Security check every week. That person does not need an estate plan, right? There's nothing really to do with that. They might need to plan their funeral and let their kids know what they want there. So we turn those people away. Look, there's no need to pay me to do anything because you don't have enough to worry about. But if you've got kids or real property, having a trust, having an estate plan is a critical part of expressing love to your family.
This is a two-part question because I know I'm thinking it, so our audience is probably thinking it too. How long does it take to set up a trust, and how expensive can this be?
Oh, those are two really good questions. So how long it takes in all candor is going to depend on your life and my life and the complexity of what we're trying to do. In addition to doing estate planning, I do court work. Now that court work informs how I handle estate planning because I've litigated probates. I've litigated these nasty, horrible fights where some of my colleagues that only do the transactional parts of an estate plan haven't. So I kind of approach it from trying to prevent the fight, which is different from some of my colleagues. So if I'm looking up, I'm heading to court for 3 days next week, it's going to be 2 weeks. If I've just settled a case and I don't have court next week, it might be a couple of days. Generally 1 to 2 weeks most of the time is our time frame for getting an estate plan put together for someone once we get all of the information. Now the cost is going to vary. I've done estate plans $1,500, $2,000 in the last 6 months, and I've done estate plans that were $40,000, $50,000. It just depends on what we're trying to accomplish, what our goals are, and what complexity you need given your circumstance. So most people, a good estate plan is going to be anywhere from, say, $2,000 to $4,000 to get it done right. With an attorney, it's going to take enough time to get to know your circumstances. It isn't just doing a find and replace in Microsoft Word. It's going to make sure that things are set up the way you want them set up.
Excellent. This has been very helpful. Great detail and perfect stories to help drive it home for us to understand it. Thank you so much for your time today, Travis.
You bet.
That's it for today's episode of the Greater Zion Law Podcast with Travis R. Christiansen. If you'd like to learn more about estate planning in Utah or speak with Travis about creating a plan that fits your family and goals, visit greaterzionlaw.com. Thank you so much for listening. And don't forget to subscribe, leave a review, and share this episode with someone who might need it. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.